Welcome to the Deep Dive. Today we're diving into something really fundamental in India's criminal justice system, the First Information Report. You probably heard it called an FIR.
Absolutely. It's that critical first step when a serious crime happens, what the law calls a cognizable offense.
And things have changed recently, right? There's this new law, the Bharatiya Nagarik Suraksha Sanhita, the BNSS from 2023.
That's right. It replaced the old Code of Criminal Procedure, the CrPC, from way back in '73. So understanding FIRs now means understanding them under the BNSS.
Okay, so for this deep dive, we've looked at, well, quite a bit. Government advice, articles on the new law, police procedures, even comparisons between the old CrPC and the new BNSS.
And some basic explainers, too, trying to cover all the bases.
Our mission today really is just to give you a clear picture. What is an FIR? How does it work now? What are your rights? Answer those common questions.
So you feel empowered, if you ever need to interact with this system.
Exactly. Okay, let's start at the beginning then. What is an FIR? Like in simple terms.
Well, FIR just stands for First Information Report. And it's basically what it sounds like, the very first information the police get about a potentially serious, cognizable crime.
So it's the first report. But is it, like, formally defined in the law?
Interestingly, no. The term FIR isn't explicitly defined in the BNSS or the old CrPC. But Section 173 of the BNSS, which used to be Section 154 in the CrPC, that's the section that deals with how this information is recorded.
So not officially defined, but it's the thing that, gets the ball rolling.
Yeah.
Starts the whole police investigation process.
Precisely. It's the document that officially kicks off the criminal proceedings for those types of offenses. It's really important.
Okay, so what makes something an FIR? Are there specific things it has to be?
Yeah, there are key characteristics. First, it's got to be a written document, and it's prepared by the police.
Okay, written by the police.
Usually it starts from a complaint made by the victim, or maybe someone else reporting on their behalf. But the information itself, it could come in different ways. Someone might tell the police officer, so it's oral, or they might give a written statement. Or, interestingly, it could even start from, say, a phone call.
Wait, even a phone call reporting a crime can lead straight to an FIR. How does that work logistically?
Well, if the information comes in orally, the police officer has a duty to write it down. It's not just optional.
Okay, they write it down.
Then, crucially, the person who gave the information, the informant, they have the right to have it read back to them.
To check it's right.
Exactly, to
Yeah.
ensure accuracy. And once they confirm it's correct, they need to sign it. Or, if they can't read or write, provide a left thumbprint.
Makes sense.
And another key step, the police must record the substance, the core information of that report in something called the general diary.
The general diary, what's that?
Think of it like the police station's official daily logbook. Everything important that happens gets recorded there. It's for accountability.
Got it, like a master record.
And one last really important point. The person who provided the information, the informant, must be given a copy of the registered FIR completely free of cost.
That's a key right to know about. Okay, so you've mentioned cognizable offense a few times. We need to unpack that. What's the difference between that and, well, other kinds of offenses?
Yeah, this is a fundamental distinction in Indian criminal law. Offenses are basically split into two categories, cognizable and non-cognizable.
Okay, cognizable first.
Cognizable offenses are generally the more serious ones. Think murder, rape, kidnapping, major theft, crimes where the police need to act fast.
All right, serious stuff.
For these, the police have the power to arrest a suspect without needing a warrant from a court, and they can start the investigation immediately on their own authority. An FIR is registered for these cognizable offenses.
Okay, so FIR, serious crime, police can act immediately. What about the other kind, non-cognizable?
Non-cognizable offenses are generally less serious. Things like maybe simple assault, cheating, forgery, defamation.
Okay, less severe.
In these cases, the police usually cannot arrest someone without a warrant, and they can't start investigating without permission from a magistrate's court.
So no automatic investigation?
No. Typically, for a non-cognizable offense, an FIR isn't filed. Instead, the person who feels wronged, the complainant, would usually make a complaint directly to a magistrate.
I see. So the court gets involved much earlier for less serious things.
Essentially, yes. And if you want the full list of which crime falls into which category, you'd look at the first schedule, the BNSS. It classifies all the offenses.
Good to know where to look. Okay, so let's say someone needs to file an FIR for a cognizable offense. Walk us through the steps they should expect. What's the procedure?
Right. The procedure is laid out in Section 173 of the BNSS, the old Section 154. First step. You, the informant, provide information about the cognizable offense to the police.
Orally or in writing, as you said?
Correct. If you give it orally, the officer must write it down. That's step 2.
Yeah.
Step 3, you have the right to have it read back to you. Always ask for this if they don't offer.
Check for accuracy.
Got it. Step 4, you sign the statement once you're satisfied it's accurate.
Or thumbprint.
Or thumbprint, yes. Step 5, the police record the substance of it in their general diary.
The logbook.
And step 6, you get your free copy of the registered FIR. Don't leave without it.
Okay, that sounds pretty clear. What kind of details should someone aim to include when they're giving that information?
The clearer, the better, really. Definitely your name and address, the date, time, and crucially, the exact location of the incident.
To be specific about where it happened.
Yes. And then just the true facts of what happened. As you saw or experienced them, stick to the facts.
Right. No opinions, just what occurred.
Exactly. If you know the names or can describe the people involved, include that. And if there were any witnesses, their names too, if you have them.
Okay, provide as much factual detail as possible. Now, this all seems straightforward, but, you hear stories. Police sometimes seem reluctant to register an FIR. Is it actually mandatory for them?
That's a huge point. And yes, it is mandatory in specific circumstances thanks to a landmark Supreme Court case, Lalita Kumari versus Government of UP from 2013.
Lalita Kumari.
Yeah.
Okay, what did that case establish?
It laid down some really clear rules. The headline is, if the information given to the police discloses, on the face of it, that a cognizable offense has been committed, then the police must register an FIR, period.
Must register. No ifs or buts.
No ifs or buts in that scenario. And importantly, the court said no preliminary inquiry is allowed before registering the FIR in such clear cases. They can't say, we'll look into it first, if the information clearly points to a serious crime.
That's a major clarification. Yeah. So it stops them potentially brushing things under the carpet.
That was precisely the concern the court addressed. They wanted to prevent police from avoiding registration. However, the court also acknowledged that sometimes the initial information might be a bit vague or unclear.
Right. Maybe it's not immediately obvious if it's a serious crime.
Exactly. In those specific situations where it's not immediately clear if a cognizable offense is made out, the court said a preliminary inquiry may be conducted.
Okay, an initial check.
Yes, but only for the purpose of finding out whether a cognizable offense is actually disclosed by the information. That's its sole purpose.
Not to decide if the information is true or not.
No, not at this stage. Just, does this information suggest a cognizable offense happened? If the preliminary inquiry confirms that yes, it does, then the FIR must be registered immediately.
And what if the inquiry suggests, no, it doesn't seem like a cognizable offense after all?
Then the police would close the complaint at that stage. But they must inform the original informant, in writing, within 1 week explaining the reasons for the closure. Transparency is key.
Okay. And are there consequences for police if they just ignore this, if they don't register an FIR when they should have?
Absolutely. The Lalita Kumari judgment was very clear. Police officers who fail to register an FIR for a cognizable offense can face disciplinary action. They could even be prosecuted under Section 166A of the old CrPC. The new laws have similar penalty provisions, which could mean imprisonment or fines.
So there are real teeth to this requirement.
Yes. And the court also stressed the police cannot refuse to register an FIR just because they doubt the information's reliability or the informant's credibility. Those are matters for the investigation after the FIR is lodged.
That's crucial. Don't judge the story. Just record the complaint if it indicates a serious crime.
Precisely.
Did the court give examples of when a preliminary inquiry might be okay, besides just general vagueness?
It did give an illustrative list, not exhaustive, mind you. Things like matrimonial or family disputes, commercial offenses, cases of alleged medical negligence by doctors, corruption cases.
Okay, areas where things can be complex.
Right. And also cases where there's been an unusual delay in reporting, say, over 3 months without a good reason. But again, even in these, the inquiry is just to see if a cognizable offense is revealed, not to verify truth. And it should be quick, generally within 7 days.
7 days. That's a tight time frame.
Yes. And any delay beyond that needs to be justified and recorded in the general diary. The court really wanted to stop inquiries being used as an excuse for inaction.
Okay, so the rule is generally register first if it looks like a serious crime. But realistically, what if someone goes to the police, reports a cognizable offense, and they still refuse to register the FIR? What can that person do?
Thankfully, the law provides options. The first step under Section 173, subsection 4 of the BNS, that's the old 154 of CrPC, is to send the substance of the information, in writing, perhaps by registered post, to the Superintendent of Police, SP, or the relevant Deputy Commissioner of Police, DCP.
Go above the station house officer's head.
Essentially, yes. If the SP or DCP is satisfied that the information discloses a cognizable offense, they can either investigate the case themselves or they can direct a subordinate officer to register the FIR and investigate.
Okay. Approach the senior officer. What if that doesn't work either?
Then the next step is the courts. The person can file a private complaint directly before the concerned magistrate. This is under Section 175 of the BNSS, which corresponds to 156 of the old CrPC.
A private complaint to the judge.
Yes. The magistrate will look at the complaint. They might examine the complainant under oath, and if they're satisfied that, prima facie, a cognizable offense seems to have been committed, the magistrate has the power to order the police to register the FIR and conduct an investigation.
So the court can compel the police to act.
It can, and there's potentially one more avenue. If the police refusal seems motivated by bias or, say, corruption, the person could also lodge a complaint with the State Human Rights Commission or the National Human Rights Commission.
Right, if it looks like misconduct. Those are good options to know about. Now, something else I wanted to ask about is the Zero FIR. What's that all about?
The Zero FIR. It's a really important and practical provision. Basically, it means you can report a cognizable offense at any police station, irrespective of whether that station actually has the territorial jurisdiction, the authority over the area where the crime happened.
Any police station at all, even if the crime happened hundreds of miles away.
Yes. Let's say a crime happens in City A, but the victim travels to City B and wants to report it there. They can go to a police station in City B. That station is obliged to record the information and register what's called a Zero FIR.
Why zero?
Because they assign it the FIR number 0. This signals that the crime occurred outside their jurisdiction. After registering the Zero FIR, that police station must then promptly transfer the case documents electronically or otherwise to the police station that actually has jurisdiction over the place where the crime occurred back in City A.
And the police in City A then take over.
Exactly. The police station with the proper jurisdiction will then register a fresh FIR with their own regular serial number and proceed with the investigation.
That sounds incredibly helpful. It stops victims being sent from one station to another, right? Especially if they're vulnerable or traumatized.
Precisely. It removes that immediate jurisdictional barrier to just getting the crime officially recorded. It prioritizes the victim's need to report.
Was this always the case? Is Zero FIR new?
The concept has been around. The Ministry of Home Affairs actually recommended it specifically for crimes against women back in 2015. But now, the BNSS, under Section 173, has given it formal legal backing for cognizable offenses generally.
So it's properly enshrined in law now.
Yes. And police procedures, like the Pituitary Police SOP we looked at, really emphasize this. It says the station house officer, the SHO, must register a Zero FIR without delay if they get info on a cognizable offense outside their area.
Must register.
Yes. And they have to transfer it electronically or otherwise, inform the complainant it's been done and where it's gone, and record it all in the general diary. The SOP even warns that failure to register a Zero FIR when required will lead to action against the SHO.
So they're taking it very seriously.
They have to. It's about access to justice.
Okay, what about the digital age? Can FIRs be filed online now? E-FIRs.
Yes. The BNSS specifically provides for electronic registration of FIRs, or E-FIRs, also under Section 173.
How does that typically work?
Usually, the complainant would submit the information through an official police portal or website, maybe even via email or another designated electronic channel. They'd provide their details, the incident specifics, maybe upload documents.
So potentially report from home.
That's the aim. The submitted E-FIR then goes for some initial verification. Interestingly, the BNSS mentions for offenses punishable with 3 to 7 years imprisonment reported electronically, a preliminary inquiry might happen within 14 days, but only with permission from a senior officer, a DSP, or above.
Okay, a check for those mid-level offenses reported online.
Right. And a key step for E-FIRs, usually, is that the complainant needs to digitally sign or somehow authenticate the electronic complaint within 3 days for it to become a formally registered FIR.
Within 3 days. Okay.
Once it's formally registered, they must get a free copy immediately, electronically or otherwise. Then the SHO assigns it for investigation like any other FIR.
What did the police procedures say about handling these?
Well, the Pituitary SOP, for example, requires stations to maintain an e-complaint register. It also says the SHO should contact the e-complainant, maybe by email or phone, and ask them to come to the station to physically sign the printout of their complaint.
Ah, so still a physical signature often needed.
According to that SOP, yes, for the formal registration. They need to record all this contact, and if the person doesn't show up within the 3 days mentioned in BNSS, they record that too. But if the complainant comes even after 3 days, the SHO should still take the signature and register the FIR then.
So it allows for some flexibility if someone can't get there immediately.
It seems so. The focus is still on eventually getting it formally registered.
Okay. Now, you mentioned preliminary inquiries a couple of times, particularly in the Lily to Kumari context and for E-FIRs. The BNSS seems to formalize this more. Section 1733.
Yes, that's right. Section 173, subsection 3 of the BNSS specifically addresses preliminary inquiries. It states that for offenses punishable of imprisonment between 3 years and up to 7 years.
So not the most minor, but not the most severe either. Mid-range.
Exactly. For those, if the initial information suggests such an offense might have occurred but isn't immediately clear-cut, a preliminary inquiry can be conducted.
Can be, not must be.
Correct. And crucially, it can only be done with the prior permission of a senior police officer, someone not below the rank of Deputy Superintendent of Police, DSP.
So a senior officer has to approve this initial check.
Yes. The idea is to quickly ascertain, based on the nature and gravity of the allegation, whether a prima facie case, an initial indication of an offense, actually exists.
And there's a time limit.
Yes. This preliminary inquiry must be completed within 14 days from receiving the information.
14 days.
But it's important to stress, this is only triggered if the information is initially unclear. If the information received already establishes a prima facie case for that 3 to 7 year offense, the officer should just register the FIR and proceed with the full investigation. No preliminary inquiry needed then.
So it's a tool for clarification, not delay, in those specific cases.
That's the intention. The Pituitary SOP reinforces this inquiry within 14 days. Record every step in the GD. If the inquiry concludes no offense is made out, the findings go to the SDPO.
The subdivisional police officer.
Right. And the SDPO then has to review it and decide within that overall 14-day window whether to close the matter or order FIR registration. It mandates meticulous record-keeping throughout.
It seems there's a real push for documentation and accountability throughout this process. The general diary keeps coming up.
It's absolutely central. The Supreme Court police manual is the new law. They all emphasize recording actions in the general diary. It ensures transparency and holds officers accountable for their decisions, whether it's registering an FIR, conducting an inquiry, or closing a complaint.
And we mentioned penalties earlier, like Section 166A in the old code, for not registering an FIR when required.
Exactly. There are consequences for inaction. But the accountability works both ways. If someone deliberately files a full FIR, provides false information to mislead the police,
What happens then?
they can be prosecuted. Chapter 11 of the Indian Penal Code deals with offenses related to giving false evidence and offenses against public justice. So misusing the FIR process has serious consequences too.
Right, so the system has checks and balances. Okay, let's switch gears slightly. Once an FIR is registered, what's its actual value in court? Is the FIR itself considered proof that the crime happened, as stated?
That's a really common misconception. An FIR is not substantive evidence, meaning the court doesn't treat the contents of the FIR as proven fact just because it's written down.
Why not? It's the first official report.
Because it's usually not given under oath. And the person making the statement in the FIR isn't cross-examined on it at that point. It's essentially an initial allegation or piece of information given to the police.
So if it's not proof, what's its legal use?
It has significant corroborative and contradictory value. Under the evidence laws, Section 160 of the new Bharatiya Nagarik Suraksha Sanhita, which was Section 157 of the old Evidence Act, it can be used to support the testimony of the person who gave the information, the informant, when they later testify in court.
To show they said the same thing earlier.
Exactly, to show consistency. Conversely, if the informant's testimony in court differs significantly from what's in the FIR, the defense lawyer can use the FIR to contradict them, to challenge their credibility. You said X in the FIR, but now you're saying Y.
I see. So it supports or challenges the witness later on. What if the FIR contains a confession from the person accused?
Generally, a confessional statement made by an accused person to the police in an FIR is not admissible as evidence against them. That's a safeguard under evidence law, Section 23 of the BSA.
So a confession in the FIR can't be used to convict them.
Not directly as a confession, no. However, if an FIR lodged by someone who later becomes the accused contains non-confessional information about the incident, parts of it might sometimes be used, perhaps as corroborative evidence related to their conduct or knowledge, but not as an admission of guilt itself. It's a nuanced area.
Okay, so mainly used for corroboration or contradiction of the informant's later testimony,
Yeah.
not direct proof itself.
That's the main evidentiary role, yes.
This has been incredibly useful. Let's try and recap the main takeaways about FIRs, especially under this new BNSS framework. What are the absolute key points for listeners?
Okay, sure. I'd say point one, mandatory registration. If the info reveals a cognizable offense, police must register the FIR. No preliminary inquiry in clear cases. That's the Lalita Kumari principle, now reinforced.
Well, it's registered. Got it.
Point two, accessibility through Zero FIR. You can report a serious crime at any police station, regardless of jurisdiction. They register a Zero FIR and transfer it. Big step for victims.
Removes barriers. Okay.
Point three, E-ARs. Electronic filing is now formally part of the law, making reporting potentially easier, though procedures like signing might still apply.
Digital option.
Good for. Preliminary inquiries are now specifically regulated under Section 173 for those 3 to 7 year offenses if the info is unclear, and only with DSP permission and within 14 days. It's not a general pre-registration check anymore.
More defined and controlled inquiries.
Exactly. And finally, point five, accountability. Strong emphasis on documentation, general diary, and consequences for police inaction penalties and for false complaints.
Accountability on both sides.
Mm-hmm. Really, understanding these provisions empowers you, the citizen. It helps ensure that when a serious crime occurs, the justice process can start effectively and hopefully without discrimination or undue delay.
Absolutely. This deep dive really highlights how crucial the FIR is as that first step. And these changes, the Zero FIR, the E-FIR provisions, the clarification on mandatory registration, they genuinely seem aimed at making the system more responsive and accessible.
That's certainly the goal on paper.
It definitely makes you think about how these legal frameworks shape our actual experience with law enforcement and seeking justice. If you want to explore further, looking into the full Bharatiya Nagarik Suraksha Sanhita 2023 would be the next step.
Definitely worth a read for anyone interested in the details of the new criminal laws.
Thanks so much for breaking all that down, and thank you for joining us on the Deep Dive.